Welcome everybody to this MCEA webinar. This is the third in a series of webinars that we've been doing to give our donors and supporters sort of an inside look at some of our legal cases, in particular our cases around the PolyMet mine. So welcome to you all, and I want to just say thank you. Thank you for being an MCEA supporter. Thank you especially if you're one of our sustaining donors. Those are the folks who give monthly, and you know, as we're looking forward into some rocky times, not knowing necessarily what to expect over the next few months, it's really important for us to know that we have supporters who have committed to being with us each month. So if you're able to do that, we certainly would welcome it. Thank you for being here, and thank you for your support. I want to also give a shout out to several legislators who I believe are joining us today. Thank you for all the work that you're doing up at the legislature. Thank you for being here. My name is Kevin Reuther. I'm the Chief Legal Officer at MCEA, and with me today is Evan Mulholland. Evan is our supervising attorney. He's also the lead attorney on the case that we're going to be addressing today, the main case, which is our challenge to PolyMet's air permit. What we have planned is about 30 minutes, so we've set aside 30 minutes. We'd like to talk initially just briefly about some of the background about PolyMet, make sure that we're all on the same page, and why we're spending so many resources on this particular challenge. And then I'd really like to spend the bulk of our time talking with Evan about the air permit challenge and going a little bit deeper into that. We're also going to address news that we got on Wednesday, which is that we'll be headed to the Supreme Court on our challenge to the DNR permit. So we'll talk about that a bit, and hopefully we'll leave some time towards the end for your questions. I did want to note that at the bottom of your screen, there should be a little button that says Q&A, and that's the place where you can write your question. We have access to the screen, and so I'll be able to read those. Evan, I'm sure will have really good answers. If we don't get to all of them, you know, we can try to follow up, or you can always email us. Mm-hmm. So Evan, why don't we get started? You want to say hi?
Sure. Hey, everyone. Thanks for joining us. I'm Evan Mulholland, staff attorney at MCEA. I'm pretty excited to do this. This is, you know, broadcasting from home, so here we go.
Here we go. So let's start with kind of the big picture question of why PolyMet. I mean, we're obviously devoting a lot of resources to this project. I think at one point we had 7 or 8 pending cases. Now maybe 4 or 5 are still pending, including this air appeal that we're going to talk about. Why is this so important?
Sure. Great question, Kevin. So we've been working really hard on PolyMet a lot of time for the past 2 years, and also for the past 10 years working on PolyMet, working on the permits, working on environmental review. And there's a couple of key reasons for that. First, we and the industry and the government sees PolyMet as a snowplow that will, according to PolyMet and the mining industry, will clear the way for the other copper nickel mines that are on the drawing board for the range. However this one goes, will lay the pathway for the other ones. That's the main reason why this is so important.
This is the first of several.
Yeah, first of several proposals. There's twin metals, which I'm sure many of you have heard about, and there are also some other ones that are, you know, more on the planning stages. And
getting this right is really important.
Absolutely, it is. Mainly for one specific reason, which is the state doesn't have a good track record of regulating mining. There's the, you know, the taconite industry that has a lot of power, and the state sometimes has difficulty in making sure all the permits are followed and renewed timely. And second,
well, I just wanted to say we have a really good example of that in the Mintech facility, where it took MCEA filing a lawsuit actually to get the PCA to update Mintech's permit. It was expired for, I think, 25 years. And the pollution up there has been a real big problem. So that's definitely, yeah, an issue that regulating that industry has been difficult.
And on top of that, this type of mining, the copper nickel mining, where the ore is inside sulfur containing rock, it's more dangerous because of the acid mine leakage and the potential for serious environmental damage from accidents and just leachate from the tailings basins.
Good. So as I mentioned, there are a number of other cases aside from the air permit case that we've had. Can you give some background, just some context on
Sure.
those?
As many of you probably know, the PolyMet mine needs several permits from different agencies to operate, and we've challenged almost all of those. The main permits from DNR are the permit to mine and the dam safety permits. And we challenged those, and the Court of Appeals agreed with us and sent those, revoked those permits and sent it back to DNR. But we just found out on Wednesday that the Minnesota Supreme Court agreed to take those cases and review those at PolyMet's request. Second is the water permit, the water discharge permit issued by MPCA. And that permit is still in the state district court because of the irregularities around the record and the potential or likely hiding of documents and information. And lastly, the PolyMet mine will also require a wetlands permit from the Army Corps, from the federal agency. And we've challenged that also with our attorneys at Earth Justice, and that's in federal district court.
Great. Okay, so let's turn specifically then to the air permit challenge. And I think it'd be helpful if you could give some background, just general background about the Clean Air Act and why it is that PolyMet needs an air permit. I want to pause though to tell folks sort of a little bit about your background, Evan, that Evan is actually an expert in the Clean Air Act. He comes to us from the air agency in New Hampshire, where he was supervising a team of staff there responsible for their Clean Air Act compliance. So it's been really great to have Evan on our staff. He's the one that came up with this whole sham permitting idea that you're going to hear about that's alleged in the challenge that we have to this air permit. So anyway, Evan, give us a little bit of kind of the general background of Clean Air Act. What's it about?
Sure. Thanks, Kevin. Why PolyMet needs an air permit? What the air permit does is it specifies what type of controls a facility has to control air pollution emitted from the facility. And it also describes and requires certain monitoring, record keeping, and inspection frequency conditions in order for a facility to operate and continue to emit into the air. So the way the Clean Air Act is set up, really briefly and sort of high level, is that the federal government set national ambient air quality standards, known as the NAAQS and AAQS. And the point of these is to make sure that all of the air quality in the country is lifted to those minimum standards. And also to make sure that areas of the country that are already above those standards, that the air quality doesn't deteriorate. And the way the Clean Air Act does that is to focus on what's known as major sources. These are sources of facilities that have the potential to emit more than a certain threshold of tons of certain pollutants during a year. And that limit's usually 250 tons.
Just to
go ahead.
Quick, Evan, to clarify, Minnesota, we are under the threshold, right? We're trying to prevent deterioration.
Right. All of Minnesota is what's known as in attainment, which means that the air quality in Minnesota is better than the national standards.
Good.
So through the Clean Air Act's focus on major sources, the major sources are required to use what's called best available control technology. In other words, it's a technology forcing scheme such that major sources are required to control air pollution to the best level that's technologically possible. And these major sources also have more stringent monitoring and inspection regimes.
So in this case, Evan, what is it that when you were reviewing the air permit for PolyMet that you discovered, and what is the claim that we made?
So it's really interesting. In this case, and let me see how I should start here. So there's a way through the Clean Air Act, if you normally would be a major source, but you don't want to be subject to all those stringent requirements I just discussed, you can ask the permitting agency, here is the PCA, to allow you to limit your operation to below a certain level such that your emissions would presumably stay below that threshold to become a major source. This is called a synthetic minor permit. In
so
other
that's
words,
what PolyMet applied for, a synthetic minor permit. They
yes,
were saying, we're not a major source. Don't make us do all those stringent requirements. We're really just a minor source.
exactly. The problem, however, is what we discovered when we've been working on this case for a long time, and we found that PolyMet was saying one thing to the regulators and another thing to its investors. And specifically, it told its regulators through this permit application that it would stay under the 250 tons per year. And the way they would do that is limit their throughput of ore through their processing facility to 32,000 tons per day, which is an enormous amount of ore. But their facility has the physical capacity to run at 2 or 3 times that, because it's an existing facility with 7 crushing lines. It's a abandoned taconite facility that PolyMet had purchased.
Maybe you can describe that a little bit when you say 7 crushing lines.
Sure,
Is
yeah.
that the source of the air pollution?
The crushing lines are actually one of the biggest sources of air pollution on the site. These crushers are controlled by filters and mechanisms to control the powder from, I should say, how these crushers work. Essentially, you get these big pieces of rock and ore, and they're shipped from the mine site to the processing site, which is a few miles away. And they get crushed with these giant crushers that use enormous amounts of power that break the rock up into tiny, tiny pieces, essentially powder. And then they can spin the metal out using flotation and circulating devices such that the metal goes one way and the waste rock goes the other way back to the tailings basin in a powder form. You can imagine if you're crushing all this rock, you end up with a lot of dust, a lot of fines, and that's one of the major concerning and controlled sources of air pollution from the facility.
So
what we discovered,
there are 7 of these crushers at the facility because they're reusing the old LTV facility, but they're saying to the regulator that they're going to limit how many of them they're going to use?
Exactly. They said they were only going to use 3, and the other 4 they're just going to leave idled. Well, what we found out through a filing that PolyMet made with the Canadian securities regulators and also with the United States SEC was that they analyzed what would happen if they ran more of these crushers, the crushers that they promised to our regulators they would not run. And instead of running at 32,000 tons per day, they analyzed what would happen if they doubled or tripled the ore throughput through the facility. And it turns out that it's at the 32,000 tons per day, it's barely economically feasible to begin operation. But if you triple the production rate, you make a lot more money a lot quicker if you're PolyMet.
And that's expressed in a return on investment, right? So
yes.
Describe for people what the return is at the rate at which they've applied versus the return at the rate at which they're telling their investors they could someday achieve.
So at the 32,000 tons per day level, which they applied for, the synthetic minor cap, their internal rate of return was calculated to be about 10%. And if they were to triple production, that internal rate of return, their profit, goes up to 24%. And
so I remember,
go ahead.
Well,
Kevin.
I was just going to say, I remember the first time I heard that, I reacted saying, well, 10% sounds awfully good. Like, we're calling that maybe not economically feasible, but why is it different for a mining company?
Well, there's 2 reasons. The first one is that mining companies, major mining companies like Glencore, need to seek higher returns because mining is so risky. You're not sure it's going to work out. You're not sure that metal prices are going to stay where they are. You're not sure that situations in the ground might change. And Glencore tells its investors that they look for, as a rule of thumb, a 15% return on investment in order to make capital investment in a junior project like PolyMet. So we're at 10%. Glencore is looking at 15 as a minimum, and they can get to 24 if they triple production. So the question that we ask PCA is, why would a company not do this? Why are you not analyzing whether PolyMet's essentially telling you one thing and its investors another thing?
And did we lay all this out for the PCA?
We did. We laid out the excess production capacity in our comments, and then interestingly, 10 days after the comment period ended, we got this Canadian securities filing called the technical report. And we sent that to the PCA several times. We sent it to them in June of 2018. We resent it in November. And then in December, specifically calling out this possibility that the permit was a sham. And yeah,
and what was their response to the allegation of sham permitting?
PCA responded that it was all speculative, that there was nothing they had to look at beyond the four corners of the application, even though we pointed to longstanding EPA guidance from 20 or 30 years of standing guidance that sham permitting is a thing and it is illegal under the Clean Air Act. And the PCA refused to make any findings in its final decision, which was issued in late December, issuing the permit.
All right. So all of that then was the basis for your appeal to the Court of Appeals.
Exactly.
If you can sort of describe the arguments that you made there and what the court did.
Right. Our main argument was that this action by the PCA was arbitrary and capricious because they didn't make any findings. There was no way for the court to review its decision on the sham permitting issue. And we found out that the court agreed. After argument and their deliberations, they issued an order remanding this permit back to PCA. And the reason they gave was there was insufficient findings. The PCA did not explain why they ignored our argument, our position on the sham permitting issue, and why they didn't do any investigation to analyze it. So they sent it back to the PCA.
Okay, so we want to remand back to the PCA. Now what's going to happen? What's the likely outcome here?
We expect that PolyMet and probably the state PCA will appeal or seek to have the Minnesota Supreme Court review this case. PolyMet has been very aggressive on seeking further review of everything. So we expect it will go to the Minnesota Supreme Court, which will result in probably 12 to 14, 15 months of briefing, argument, and deliberation at the Supreme Court level. But all this time, there's no way that PolyMet can start its facility because of the nature of air permitting. A facility like this cannot break ground, cannot construct without the air permit.
Mm-hmm. Okay. So I had one question here that's really specific about your 32,000 tons per year. How close to the cap for minor processing or for a minor facility is the 32,000 tons per year?
32,000 tons per day, actually. And at that rate of ore throughput, with the controls that they say they're going to use, they're at, I think, close to 200 tons of particulate per year.
Okay.
About that level.
So you mentioned that you think that PolyMet and possibly the state will seek review in the Supreme Court. Mm-hmm. That's probably a good segue for us to talk a little bit about the DNR case. Do you want to give a little bit of background there and tell people what happened on Wednesday or what we learned on Wednesday?
Sure. As many of you know, we got an amazing victory over PolyMet on the DNR permits. We challenged them and said that we should have had a contested case, which is an administrative law judge, an independent administrative law judge would look at the information and position of our experts and PolyMet's experts and the state's experts, particularly on the stability and the construction of the tailings basin. We contend that it's an unsafe design. And the ALJ, if this had happened, would have looked at all of our experts and decided who had the best argument. The DNR skipped all that and went right to permitting. And what happened at the Court of Appeals level is they sent it back to the DNR with instructions to hold a contested case. That's the main part of that decision. We recently found out on Wednesday that PolyMet's and the DNR's petition to the Minnesota Supreme Court for further review was granted, which means we're going to be going to the Minnesota Supreme Court on the DNR permits, which is a big deal. It really is.
Okay, thanks. We have a question here about the rules. So DNR has rules that obviously regulate mining. And the question is about the effectiveness of existing rules, whether they're really up to the task for regulating these sulfide mining proposals. I think we maybe have an opinion about that.
Yeah, we don't think that they are. I mean, these rules were written 30-something years ago in general on the statute, and maybe a little bit more recent on the rules. And we've been advocating for an update at the legislature, and we have not gotten much traction there. We think that the rules need to be significantly modernized, following, the lead of other jurisdictions that have dealt with this type of mining. Minnesota's behind. I don't know if you want to add, Kevin.
No, that's good. Let's see, once a determination is made by the court, will the PCA look at the historical threat of airborne asbestos in the history of Minnesota mining operations?
I don't know. Kevin, maybe you want to answer that. You're more familiar with the reserve mining case.
Yeah, my guess is not, that this case is really more about whether or not PolyMet was being truthful when they put in their application to be a synthetic miner permittee. And so it's really about the PCA investigating at this point what it is, what are PolyMet's plans? I mean, why did they have this investigation done on higher throughput scenarios for the Canadian regulators? What has happened since then, I think, is that we've gotten more information that indicates that they are more likely to expand. And Evan, maybe you can talk a little bit about that.
Yeah, sure. We found out this winter, I think it was in November, that PolyMet announced that they did more exploratory drilling at the mine site and confirmed some of the ore bodies that they suspected were there were actually there. And what that meant is they can move them from the inferred category into the, I think it's the realized, or I don't think that's the right word, but a more confirmed category, which would make it even more likely that the mine will get bigger and faster because of the profit margins.
Here's another question. Why do you think the PCA didn't look critically at this issue when you raised it?
It's a really good question. I think about that question a lot. I worked for the state and in New Hampshire, at least, for many years. And my experience with state workers and state regulators is that they really, really want to follow the science and they want to do the right thing, which is why they're in state service. I don't know what went wrong here, but we do know that the permits were issued all in a bunch right at the end of 2018 in November and December, right before the new administration was about to start, the Walz administration. And there may have been some pressure messaging to get everything done as quickly as possible. And, talking about sham permitting throws a wrench in that. So that may be, but that's just me speculating. We don't know.
Yeah. Couple questions about the timeline for a Supreme Court hearing and also a decision on the water permits. So maybe you can take the one about timeline for the Supreme Court reviewing the air permit case.
Sure. Normally the Supreme Court requires briefing, like if they were to take it, which we would find out in about maybe a month and a half, briefing would start right away, within a month and then 2 months after that. But we're also in the Supreme Court in the NTEC case, which is our gas plant case that we've challenged Minnesota Power on. And in that case, the Supreme Court, on our request, gave everyone extra time. So we expect that in this case, there will be an extended period of time to brief. One, because of the complexity of the issues, and two, because of the uncertainty of how the courts and the law firms and we will be dealing with this.
And in terms of the air permit, so the rule is that within 30 days of the decision, PolyMet and or the PCA would have to request review. And then typically the Supreme Court decides in 2 to 3 months, whether or not they're going to grant review.
Right.
So we'll know about that case sometime this summer. On the water permit, we're still in the district court. Right now, we're in briefing on that. So that case got sent from the Court of Appeals back down to the district court. We had a 2-week trial that was very intense, and we're now going through that record, writing up those briefs, and believe all the last briefs are due to Judge Guthman sometime in June, and then he will have some time to make a decision, and that case will then go back to the Court of Appeals. So we're on a longer timeline there. Let's see, we maybe have, go ahead. Did you want to say something, Evan?
Nope, I just said right.
Okay. Does the mine operator have a history of proposing synthetic miner operations and then exceeding those limits?
Kevin, I assume we mean Glencore? Because
Possibly.
PolyMet hasn't done anything yet.
Right, we wouldn't know for PolyMet. We may not know for Glencore either. I don't know. Do you have any experience with that, Evan?
No, I don't know particularly about Glencore, but what I can add is that this type of case is very rare. I mean, we researched this obviously extensively in preparation for the Court of Appeals briefing and argument, and we found no case where an environmental group like ours had challenged a permit based on the company saying one thing to the regulators and one thing to the investors. Mainly because most companies don't do that, and at least they don't do it in writing with filing at the SEC. So I was surprised that they did that. It seemed like it gave us an opening to challenge their permit on this issue, and I think we made some new law here on Clean Air Act.
Didn't you say the other day that you hadn't found any cases anywhere that refer to the Sham permit?
There are only maybe 2 or 3 reported cases in the entire country that use the term and the concept of sham permitting. Mainly this happens when a company has a synthetic miner permit and then either by accident or on purpose exceeds its limits later on. And then the enforcement agency would come in and say, you should have had a different permit from the beginning, so we're going to fine you extra for that reason. To challenge as an environmental group, as an intervener like us, is very rare. We couldn't find any that were parallel.
Yeah, I think it's pretty cool that you came up with this argument and you've won, and we've got a published decision here in Minnesota.
Thanks, Kevin.
So congrats on that. A question here about going to the Supreme Court. When is the last time that MCEA was at the Supreme Court?
Kevin, we were talking about this before. Correct me if I'm wrong, but it's been probably about 10 years since we've been in the Minnesota Supreme Court?
I think that's right, yes. The last time we were there was on a water permit, and I think it was my argument. And so it's pretty cool, actually, that we're headed to the Supreme Court on your gas plant case, the Minnesota Power's proposal to build the new gas plant in Superior, Wisconsin. That's going to be before the Supreme Court, and then also on this other PolyMet DNR permit.
Yeah, I'll just add that, Kevin, that the group may not know that the Supreme Court doesn't take every case. The Minnesota Supreme Court takes a small fraction of the cases that are presented to it, and very few of those are environmental cases. So it's a big deal. That's
exactly true. And obviously, since you folks on the line are donors and supporters, you know how important it is to have resources to be able to litigate these cases. And so I see that our time is up, but I just wanted to give you another shout out and big thank you for your ongoing support. It's your donations that make this work possible, and we're very appreciative of that. So I think we're going to sign off for now. Thanks for participating today.
Yeah, and also, if you have other specific questions, feel free to send us emails. I mean, our email's on the website, and it'll get to us, so anytime. Thank you.
Great. Thanks so much.